Welcome back, dear friends. This is episode number 26 of the Limitation Act. We were dealing with section 14. I have read 14.1, 14.3 and 14.2 and also the explanation. 14.3 I have not read, and I also said that 14.3 is little bit difficult. I also said that along with 14.3 we have to consider Order 23 rules 1 and 2, and then also 14.1. It must be read together, and see, the wording is slightly complicated. Let us see. We need not be afraid of it. We have to face it. So we will face it. How? Notwithstanding, it starts with a non-obstante clause. Notwithstanding anything contained in Rule 2 of Order 23 of the Code of Civil Procedure 1908. The provisions of subsection 1 shall apply in relation to a fresh suit instituted on permission granted by the court under Rule 1 of that order, Order 23. Where such permission is granted on the ground that the first suit must fail by reason of a defect in jurisdiction of the court or other cause of a like nature. On a plain reading, nobody will understand it. Unless we go to Order 23 Rules 1 and 2 and also 14.1. Now let us see, approach it again. Notwithstanding anything contained in Rule 2 of Order 23. So we will go to Rule 2 of Order 23. What is Rule 2 of Order 23? What is Order 23? Withdrawal and adjustments of suits. Rule 1 provides for, Rule 1 of Order 23 provides for abandonment of a suit and withdrawal of a suit. Withdrawal from a suit, that is the expression used. Abandoning, you abandon, that is your volition, but there are certain consequences. But if the plaintiff is a minor, such abandonment is not possible under certain conditions are satisfied. Subrule 3 of Rule 1 of Order 23 provides for withdrawal from the suit. We will read that. Where the court is satisfied, what? A. That a suit must fail by reason of some formal defect. Or B. That there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of the suit or part of the claim. It may, court may, on such terms as it thinks fit, grant the plaintiff permission to withdraw from such suit or such part of the claim, with the liberty to institute a fresh suit in respect of the subject matter of such suit or such part of the claim. Plaintiff is the dominus litis, he may abandon, he may withdraw, no harm. But if he withdraws, withdrawal of a suit, two kinds. One is withdrawal without permission of the court, two, withdrawal with the permission of the court. What will happen if it is withdrawal without the permission of the court and withdrawal with the permission of the court, for which we have to see Subrule 4 of Order 23 Rule 1, which says where the plaintiff A. abandons any suit or part of the claim under Subrule 1, which we have seen. B. withdraws from a suit or part of the claim without the permission referred to in Subrule 3. he shall be liable for such costs as the court may award and shall be precluded from instituting any fresh suit in respect of such subject matter or such part of the claim. So a person abandons a suit or withdraws from the suit without the permission of the court. There is a disqualification for him. He cannot file a fresh suit in respect of the same subject matter. That is a restriction. That is a disqualification. But if he withdraws from a suit with the permission of the court, as is provided in sub-rule 3 of rule 1 of order 23, then what will happen is the question. So we will see for again where a plaintiff abandons any suit or part of the claim under sub-rule 1 of rule 1 of order 23, or withdraws from a suit or part of the claim without the permission referred to in sub-rule 3, he shall be liable for such costs as the court may award and shall be precluded from instituting a fresh suit in respect of the subject matter or part of the claim. So here we are concerned, while dealing with 14.3, we are concerned with withdrawal from the suit and the interpretation of rule 2 of order 23. So to understand rule 2 of order 23, we have to understand rule 1. Rule 1 of order 23 contains abandonment, contains withdrawal from the suit. Abandonment can be had consequence, he will be debarred from filing a fresh suit in respect of the same subject matter as provided in sub-rule 4 of rule 1 of order 23. Withdrawal from the suit takes place in two circumstances with two ways. One, without the permission of the court, and two, with the permission of the court. Which is the provision? Sub-rule 3 of rule 1 of order 23. So if no permission is granted, the plaintiff is precluded from instituting a fresh suit on the subject matter in respect of the subject matter of the suit. If permission is granted, he may file a fresh suit. So this much is clear. Then what is rule 2 of order 23? We are concerned with rule 2 while dealing with section 14.3 of the Limitation Act. We are concerned with rule 2 of order 23, CPC. Rule 2, what is it? Limitation law not affected by first suit. In any fresh suit instituted on permission granted under the last preceding rule, the plaintiff shall be bound by the law of limitation in the same manner as if the first suit had not been instituted. So we have seen under sub-rule 3 of rule 1 of order 23, a plaintiff may withdraw from the suit with the permission of the court. Permission can be granted on the grounds mentioned in sub-rule 3. If permission is granted, he may file a fresh suit. If permission is not granted, he cannot file a fresh suit in respect of the subject matter as provided in sub-rule 4 of order 23 rule 1. What happens, what is the law with respect to, what is the position with respect to law of limitation for the fresh suit? So you see, I filed a suit on 1/1/2019 in a court. After some time I found that there is some difficulty. See, I apply for withdrawing from the suit. That application took about 6 months time or 3 months time to dispose it of. Withdrawal was permitted. So by that time 3 months are over. Withdrawal was allowed on 31/3/2019. So from 1/1/2019 to 31/3/2019, my other suit was pending. That suit was filed almost on the verge of limitation. So on 31/3/2019, if I file a fresh suit, it is barred by limitation. It is barred by limitation. So I applied for withdrawal. Court granted permission. I filed a fresh suit. But by that time, the period of limitation is over. What happens? In a fresh suit instituted on permission granted under the last preceding rule, I am reading Rule 2 of Order 23. The plaintiff shall be bound by the law of limitation in the same manner as if the first suit had not been instituted. So my first suit filed on 1/1/2019, disposed of, withdrawn on 31/3/2019. On 1st April, I filed the second suit, fresh suit. By that time, the suit is barred by limitation. Permission was granted by the court to withdraw from the suit. So it is with the permission of the court. But that is not a guarantee for protecting you from the law of limitation, applying the law of limitation. You may withdraw it, you may file a fresh suit or not file it, it is your liberty. But if you do it, see that it is within limitation. Withdrawal with permission or without permission, that the consequences are different, but even if permission is granted, that is not a guarantee for saving from limitation. You cannot claim that period to be excluded for the purpose of limitation, is what is stated in Rule 2 of Order 23. Order 23 Rule 1 says about withdrawal from the suit under sub-rule 3 of Rule 3, where the court is satisfied that the suit must fail by reason of some formal defect or there are other sufficient grounds. These are the two grounds on which a withdrawal from a suit can be permitted by the court. So permission was granted. What are the grounds? Suit must fail by reason of some formal defect or there are other grounds, other sufficient grounds. Very flexible. There may be several grounds. Permission was granted. You filed a fresh suit, but that was out of time. Next day of the withdrawal, you filed a fresh suit without spending time. But going by the law of limitation, that is a last day is over. Court cannot condone it. So unless the period occupied by the previous suit is excluded, your second suit is barred. No exclusion under Rule 2 of Order 23. It says otherwise. In a fresh suit instituted on permission granted under the last preceding rule, the plaintiff shall be bound by the law of limitation in the same manner as if the first suit had not been instituted. So by a fiction, it is presumed that you have not instituted any first suit. You have instituted the fresh suit, second suit. What is that, whether it is barred or not? Look into that. If it is barred, out. If it is not barred, all right. You cannot claim any benefit going by Rule 2 of Order 23. For filing a suit, fresh suit, after getting permission for withdrawal from the suit as provided under sub-rule 3 of Rule 1 of Order 23. This much is clear. Now we will come back to section 14.3. Come back to section 14.3. Notwithstanding, see, when I was whenever I used to take class for the students or lawyers, I used to ask a question whether you have understood it. And I don't mind explaining it any number of times if you have not understood. One person should not leave the room without understanding it. So whenever a class is taken, the viewers must understand it. But such a facility is not available in this video class. See, only in webinar it is possible. That is only before a limited audience. This is for, see, any number of persons can watch, any number of persons can be benefited out of it, and it is permanent. So that I cannot put a question to you whether you have understood it, and I cannot get your reaction out of it. That is why I am explaining it again and again and again. Even, see, somebody may think, I have understood it, why this man is explaining again and again and wasting time. It is not wastage of time. There may be among you a very young man who is a law graduate or undergoing his studies who may not understand it. There are persons and persons. Some may be having quick grasp. Some may be having low IQ. So far as study is concerned, he may be good in some other field. So we have to take care of all those people. So that is why I am sorry, I am explaining it again and again to dispel any doubt whether any person has not understood. Let's see. See, everybody should understand it fully. That is my aim. Therefore, sometimes it may, sake of repetition, it is necessary. Please forgive me. 14.3. We have seen order 23 rules 1 and 2. Now let us see 14.3. Notwithstanding anything contained in rule 2 of order 23. Order 23 rule 2 says that no limitation, no saving. As if the first suit has not been filed, you compute limitation and find whether your second suit is within limitation or not. Notwithstanding anything contained in sub rule 2 of order 23 of the Code of Civil Procedure 1908, the provisions of subsection 1 shall apply. 1 of section 14. 1 of 14 will apply where you are prosecuting with due diligence in good faith, and because the court could not entertain it on account of any defect of jurisdiction or other cause of a like nature. That is 1. The provisions of subsection 1 shall apply in relation to a fresh suit instituted on permission granted by the court under Rule 1 of that order, or Rule 1 of Order 23, where such permission is granted on the ground that the first suit must fail by reason of a defect in the jurisdiction of the court or other cause of a like nature. Order 23 Rule 1.3 is very wide. 2 grounds are there for withdrawal, some formal defect or any other sufficient cause. These are the grounds for withdrawal with the permission of the court. Court grants permission. Need not necessarily on account of defect of jurisdiction or other cause of a like nature. There may be 100 grounds for withdrawal. Sometimes in a suit where the plaintiff has made application for amendment 10 times, it is possible. Sometimes it may be necessary also. So, but then the plaintiff looks very awkward, very clumsy. So the plaintiff may say, I will do one thing. See, to understand this plaintiff with all this restitching, adding, amending, I will file a fresh suit. Court may grant permission. I file a fresh suit. But it must be within limitation. No exclusion possible. File it within limitation. So likewise such grounds are there. There may be several types of litigation, several grounds, several circumstances where the court may grant permission to withdraw from the suit. So that permission to withdraw from the suit in subrule 3 of Rule 1 of Order 23 is different from the non-entertainment of a suit on the ground of defect of jurisdiction or other cause of a like nature, as spoken to in section 14.1. So 14.3 says, notwithstanding anything contained in Rule 2 of Order 23. Order 23 Rule 2 says that no saving of limitation. If it is barred by law, barred. Notwithstanding that, if the permission, the provisions of subsection 1 shall apply, 1 of section 14 will apply, and exclusion is possible, where such permission was granted on the ground that the suit must fail by reason of some formal defect in the jurisdiction of the court or other cause of a like nature. So there are 100 reasons for withdrawal with the permission. You carve out one item, that is withdrawal on account of the apprehension that the court may reject it on the ground of defect of jurisdiction or other cause of a like nature, and it is so true. If it is not entertained on the ground of defect of jurisdiction or other cause of a like nature, you are protected under 14(1) and that period will be excluded. That will not apply to withdrawal, all types of withdrawal from the suit. But that applies to withdrawal also, where the reason for withdrawal from the suit is that the apprehension of the plaintiff that and the satisfaction of the court that the suit must fail by reason of some formal defect in jurisdiction, or not formal defect of jurisdiction or other cause of a like nature, as is spoken to in 14(1). If that is a reason for withdrawal, notwithstanding that the provision in Rule 2 of Order 23 that there is no exclusion possible, that will not apply. That rigor will not apply. So what is provided in 14(1) is that there was a proceeding which the court could not entertain it, court rejects it, then that period will be excluded. You anticipate, or finding the contention of the opposite side, you realize lately that your suit is not maintainable. Because of defect of jurisdiction or other cause of a like nature, the court where you filed it could not entertain it. You realize it. All right, I will withdraw from the suit and file a fresh suit. But at the time of filing the fresh suit, it is barred. And Rule 2 of Order 23 says that is not, you cannot take shelter. But if the withdrawal is, the only reason for withdrawal is likelihood, or say the reason is defect of jurisdiction or other cause of a like nature, as spoken to in 14(1), notwithstanding anything contained in Rule 2 of Order 23, that period will be excluded, otherwise not. So there may be 100 reasons for withdrawal as spoken to in Order 23, Rule 1(3). All those things are not guarantee for saving of limitation. But if that withdrawal is on account of the fact that the court where the proceeding is pending is likely to dismiss it on the ground of defect of jurisdiction or other cause of a like nature, and apprehending that on sufficient grounds and the court is satisfied that that is the ground, then withdrawal is with the permission is made, that period can be excluded. This is what is contained in 14(3). So general rule is that when the court grants permission for withdrawal from the suit under Order 23, Rule 1(3), that has nothing to do with the computation of the period of limitation. That has nothing to do with the saving of limitation. No leniency will be given while computing the period of limitation for filing the fresh suit with the permission of the court. But an exception is there. If that withdrawal was necessitated on account of defect of jurisdiction or other cause of a like nature of the court where the proceeding is pending, and the court is satisfied when you apply for withdrawal that this is true, court grants permission to withdrawn, and you filed the suit in the proper court. By that time the suit is out of time. Is an exception to Rule 2 of Order 23, that period will be excluded. So 14(1) will operate fully. That will operate not only in the case of rejection or dismissal on account of defect of jurisdiction or other cause of a like nature, it applies to withdrawal from the suit also, provided the court grants permission for withdrawal and that permission is granted on the ground that there is a there is a defect of jurisdiction or other cause of a like nature. It must be clear. So this is it. So one, if you withdraw from the suit, must be very careful. There are some consequences. You cannot file a fresh suit if it is by that time it is barred by limitation. You can file a fresh suit only if there is a defect of jurisdiction or other cause of a like nature, and your application for withdrawal must specify it, and the order passed by the court also must specify it. Then it is very easy. If you file a fresh suit, that period will be excluded. So exclusion is to be made not by the court where the original proceeding was pending. Exclusion is to be made by the court where the fresh suit is filed. That court must be satisfied. So there are risks. So you must be double careful. That is why I am explaining it again and again and again. And I will cite several decisions, and none of these decisions will give you this idea. So we have to approach this. The decisions of Supreme Court and High Court are on the basis that we know the law. Certain interpretations alone that will be dealt with in those decisions. So we will go to those decisions in the next episode. Thank you. We will meet again. 2 or 3 episodes are also necessary for dealing with section 14. Thank you.